When a de facto relationship ends, it can be a difficult and confusing time for both parties, especially when it comes to dividing their assets. My name is Daniel Rod and I'm a Senior Associate at Ramsden Family Law. I'm here to tell you about the process of obtaining a property settlement after you separate for de facto relationships. So what is a de facto relationship? A de facto relationship is defined under Section 4AA of the Family Law Act, and it's a relationship between two people who are not married and not related by family, and having regard to all of the circumstances of their relationship. They have a relationship as a couple living together on a genuine domestic basis. All of the circumstances may include any or all of the following: the duration of the relationship, the extent of a common residence, whether a sexual relationship exists, and the degree of financial dependence or interdependence, and any arrangements for financial support. It looks to the ownership, use, and acquisition of property, and the degree of mutual commitment to a shared life. Other factors include looking at the care and support of children, the reputation and public aspects of the relationship. When de facto couples separate, they may have disagreements about the division of their assets, and there are several ways that de facto couples can resolve their property disputes, including using the pre-action procedures, mediation, arbitration, by commencing proceedings, or by way of a financial agreement or consent orders. So what are pre-action procedures? Pre-action procedures are steps that parties can take before starting legal proceedings with the aim of resolving the dispute without going to court. This can include exchanging information and trying to reach an agreement through informal negotiations or mediation. What is mediation? A mediation is a process where an impartial third party called a mediator helps the parties reach a mutually acceptable agreement. In the context of de facto property disputes, mediation can help the parties resolve disputes about the division of assets and property. Arbitration is another way where a neutral third party called an arbitrator makes a binding decision about the dispute. In the context of de facto property disputes, arbitration can be used to resolve the disputes about the division of assets and property. If you were to commence proceedings, de facto couples can resolve their dispute by commencing proceedings in court. This typically involves filing an application and attending a hearing where eventually a judge will make a decision about the division of assets and property. Proceedings are usually commenced in Division 2 of the Federal Circuit and Family Court of Australia. However, they can be commenced in a local court provided the amount of the property in dispute is less than $20,000. Alternatively, consent orders and binding financial agreements are both documents used to settle property disputes in de facto relationships. However, there are several key differences between the two. The first is legal status. Consent orders are court orders that are made by a judge or a registrar and have the force of a law. A binding financial agreement, on the other hand, are binding contracts between parties and not court orders. So, consent orders must be approved by a court, and binding financial agreements do not require court approval. Consent orders can only be varied in limited circumstances, such as if there's been a mistake or fraud, or if both parties agree to enter into new orders. Consent orders can be enforced by the court, while binding financial agreements can only be enforced through the courts through contractual remedies. To be valid, consent orders must be made in accordance with the Family Law Act, while binding financial agreements must be meeting the requirements of the Family Law Act and contain the certificates as set out. Importantly, there's a 2-year limitation in which proceedings for property settlements must be commenced. This time commences from the date of separation, so it's important to resolve your matter before that time. My name is Daniel Rod. I'm a Senior Associate at Ramsden Family Law. Please feel free to contact us if you have any questions or concerns in relation to your de facto separation. We have an excellent team here available to assist you at all times, and we look forward to assisting you.